Today I had traffic court, and I think there's some things that happened that you might find interesting. First off, there was a fatal traffic crash. The hearing was today. The guy ended up entering a plea in the case. However, I don't think that's what he was expecting, and I don't think that's what the defense attorney was expecting either. There was a corpus delecti argument raised. It didn't get very far, but we'll talk about that here in a few minutes. And then after that traffic fatality, actually it was before the traffic fatality, but I'm going to talk about the traffic fatality first. But before the traffic fatality, I had a contested hearing as well, and that my client was there and he was accused of T-boning a car in an intersection, and the other car had the right of way. And so we'll talk about how that went down as well. So I'm going to start with the fact that everything, of course, is hypothetical. We're talking about a hypothetical courtroom here and a hypothetical county in Florida and hypothetical cases. But I'm going to start with, even in this first hypothetical situation, I don't know all the facts. You see, the facts that I know is what I was able to overhear, the same thing that the public would be able to overhear in a courtroom. And there's a lot of things that go on behind the scenes that the public's not aware of. So what I do know about this hypothetical crash is that the driver of the vehicle hit a pedestrian or someone on a bicycle, and the driver of the vehicle confessed to the police officers that he hit the person and that he was carrying, I don't know what he confessed exactly, but the confession was done through a translator, and it wasn't just a Spanish, not to downplay Spanish, but it was an unusual language, or a much more unusual language than Spanish, that is. Man, I can't even speak. I need a translator. So the defense attorney, based upon his actions and behaviors in the courtroom leading up to him going to the podium, led me to believe that he had some type of evidentiary issue that was going to allow the citation to be dismissed. And quite frankly, unfortunate as it is, when traffic fatalities happen, there's oftentimes not a witness to put a driver behind the wheel, and so therefore the case gets dismissed. And it's just one of those unfortunate circumstances. Nobody wants to be in that circumstance. Anyways, so he goes up to the podium and starts making his argument that the case should be dismissed based upon failure to identify, or however he did it. And I don't want to say the law enforcement agency's name there, and I just did, so I'm going to have to go ahead and redact that part of it. So that's what the beep was, if you heard anything. Bottom line is, this attorney, while thinking on his feet, used the corpus delecti argument, which is generally the right argument. I'm not sure that's the strongest argument to make, but who am I when I'm sitting down in the back row listening to him up there do it? It's much easier to be Sunday or Monday morning quarterbacking somebody. Well, the judge took that into consideration and said, well, Mr. Attorney, you have a crashed vehicle, a dead body, and somebody admitting they're the driver. What more evidence do you need to show that this confession should be allowable? And the defense attorney didn't have a strong answer to that. Now, there's a ton more questions to raise here on why this ended up, to this point in time. I don't know if they could establish death certificate. There seems like there's a lot more arguments that could be made here, but nonetheless, I don't know those circumstances to make those arguments or not make those arguments. I'll just have to assume that this attorney recognized those arguments, knew about them, and made them, and they were all dead ends, which could be the case. I hypothetically wonder. But so the judge says, hey guys, go outside and talk. You guys figure it out. Let's talk about the statement. I don't want to get involved with that. You guys come back with a solution. Well, they came back and the judge ruled the statement was going to be admissible, and the guy ended up taking a plea to the careless driving, whatever the charge was. Oh, I know it was a violation right-of-way charge. I'll tell you that in a few minutes why. He took a plea to that charge, and when you take a plea to a charge, a traffic infraction charge, just like a speeding ticket, we're not talking about criminal here. When you enter a plea to a traffic infraction that's involving fatalities, then the court's required to suspend your license for 6 months, charge you a $1,000 fine, and then some community service hours that are optional. Usually the judge will give them. Well, the client wasn't ready for that information, and then going through a translator to get the information, it just didn't work out very well either. Let me tell you, I heard the translation going on in court, and I'm not sure, but if that was the same person doing the translating, I have some questions about whether the police interview was sufficient from a translation standpoint. How do we know the questions the officer were asking were being properly relayed to the client, and that the client's responses back to the officer's questions were being properly relayed? Because I'll tell you, at the court hearing today, it wasn't being properly relayed. The person, the translator, was asking and answering all the questions. So that's a concern you have with translators. It happens a lot of times when you have a familial relationship with the person you're translating for. You've already heard the story 10, 15 times at home. You know what the story is, you know what they're going to say, and so you just say it. Well, unfortunately, when you just say it, you're adding your own facts in there, and it just doesn't work. So that was a problem here, and I think that probably was an issue during the interview itself. So that's that. While this was going on, I had actually just finished up my traffic hearing. You see, in traffic court, what happens is, I guess it's set up differently depending on where you go, but in this traffic courtroom, generally what happens is all the cases that are going to resolve with a plea or some type of quick dismissal are wrapped up and kicked out of there first. That way all the people can go if they don't have any additional business. And then the cases that are going to be set for hearing are actually heard at the very end. So my traffic hearing was a go. Now there's something else you got to know about traffic court. The rules of traffic court are relaxed. The judge has additional discretion when talking about evidentiary issues to allow evidence or to restrict evidence based upon just what's right, I guess, what's right in the equitable standpoint. And so and the reason is here because you have most people not represented by attorneys. They don't know the rules of evidence. And so if you put an attorney, licensed attorney that's trained in the law and trained in the rules of evidence against somebody who has no idea, it just wouldn't be even a fair match. So, and it's just, they know the rules on how to exclude evidence, and anything you say they can object to, it doesn't work out well. So the judge, especially in a traffic hearing case, and in many cases where there's pro se defendants, the judge acts more of a gatekeeper and allowing justice to happen instead of just kicking evidence out. So I knew I was battling that a little bit here. I have the gatekeeper judge and a witness who's very hostile about my client, the fact that my client's contesting this citation. We're not in a good situation here. I'm going to put a map up on the screen, and you'll see my client was traveling southbound. Actually, you won't see it because I'm just going to show you this picture. So he was traveling southbound. We'll say that's down on your screen, getting ready to turn left onto a 2-lane road. That 2-lane road has a center suicide left turn lane, and they don't have to stop for their east and west traffic. My client has to stop because he has a stop bar in front of, or at the intersection where he's supposed to make his left turn. So he's required to come to a stop. Well, my client doesn't come to a stop, or actually does come to a stop, but he then merges out into the intersection because traffic's backed up, and he ends up striking the side of this car, which he couldn't see because of the backed up rows of traffic, and T-bones him. Minor crash, but you know, it is what it is. People get heated. Well, good news for me, the law enforcement officer assumed it was a 4-way or a 2-way stop intersection, meaning both north and southbound traffic were given a stop sign. This intersection wasn't controlled by a stop sign. Instead, it was controlled by a stop bar, a traffic control device, the line on the ground. The officer wrote the statute, or wrote my client for violating someone's right-of-way under 316.123 subsection 2A. See that on the screen right now. And what you'll see in that statute is that it requires for someone to, or is a prerequisite for issuing this citation, you have to have been at an intersection controlled by a stop or yield sign. Part of my strategy involved finding out whether the witness knew about the stop sign or the lack of stop sign at that side of the intersection. And when I asked him about the stop sign, he said, I don't know. I go through that area all the time and I don't know if there's a stop sign there. I'm sure there is. Well, that's probably not good enough for proof beyond reasonable doubt. I'm sure there is. And that's just a little nook and cranny that I needed. At that point in time, I knew I essentially had the case won. Now all I have to do is get my client to testify, yeah, he stopped, there was a stop bar there, that there was no stop sign, and that the other person agrees. Now all the evidence shows there's no stop sign. But the statute that the officer wrote my client under says must be a stop sign at the intersection. So the judge, when I presented this argument, didn't like it very much at all. In fact, challenged me on it and said, what statute should he have written him under? And for whatever reason, my trooper hat kicked back on. I spent a number of years as a state trooper before we had electronic ticket writers, and I had to memorize half that damn statute book under 316, which is all the traffic infraction stuff. Many a year sitting on the toilet reading the statute book. That's TMI, so we won't go into that. So the judge asked me what statute the officer should have used, and I quickly blurted out 316-122. Improper left turn or failing to yield while turning left. And it turns out that statute would have worked better. I don't know that it was the best statute. There's a couple different ways he could have done it, but he chose one that required a stop sign to be in the intersection, and therefore the case was dismissed. Now, let's talk about something else with that, because this hearing lasted about 25 minutes, and we were going back and forth with legal argument because the judge wanted the grounds to be solid if he's going to throw out a case. Remember, he's going in equity. So in order for the judge to hear my argument and take consideration and to throw out this case, he's kind of leaning towards the other side because he's giving them extra favor. So in order to win that argument, I had to make it several different times and paint a clear picture that the judge had no discretion here, that it's quite unfortunate my client was at fault in this accident and that he can't be found guilty in traffic court. That's what I said. So afterwards, my client came outside and said, what the hell just happened? You said I was guilty and it's all over the place. I don't know what's going on. Didn't recognize that his case got dismissed. Good stuff. Great day in court. Hit it hard. Like the video. Hey, go ahead and subscribe to this page. Have a good one.